Let's talk about the elements of driving under the influence, or DUI, in the state of Florida. When we talk about the elements of the crime of DUI, we're talking about what the prosecutor would have to prove in order to obtain a conviction against a defendant charged with driving under the influence. First, the prosecutor would have to prove beyond and to the exclusion of any and all reasonable doubt that the defendant was in actual physical control of the vehicle. Now, this is less of a standard than actually driving. You can be found to be in actual physical control of a vehicle even if you're sleeping in the passenger seat. I suggest you take a look at the Stay Out of Trouble videos or our law explanation videos if you want to learn more on this subject, because it really is interesting what Florida's policy is on sleeping off the effects of alcohol and being in an automobile, using it as shelter, if you will, or domicile for the night. And their stance on it seems to go against public policy with regard to doing the right thing and pulling over. So that would be the first element that the state would have to prove. The second element would be that the driver or the defendant was under the influence of alcohol. But many charging documents are worded in such a way that they include the language and/or a controlled substance. You can be DUI if you're under the influence of a controlled substance, an illicit substance, a prescription medication. So having a prescription will not exonerate you if you've consumed this medication to the point where your faculties were impaired. And that's your third element. The state must also prove that the consumption of alcohol or the consumption of controlled substances or the consumption of both was to the extent that it impaired the normal reflexes of the individual. The legal term for that is normal faculties. Of course, all of this can go out the window as it pertains to the extent that normal faculties were impaired if chemical testing shows that the individual had a blood alcohol level of a 0.08 or above. Now, the reason that this is important is because it is highly controversial that a machine such as a breathalyzer, a CMI Intoxilyzer 8000, can spit out a number of a 0.08 or above and relieve the jury of its duty to hold the prosecutor to proving each and every element of the crime of DUI beyond and to the exclusion of any and all reasonable doubt. But we talk about that in other videos, in other lectures, and in many of our presentation videos. So, recapping what the elements are, we have number one, actual physical control of the vehicle. Number two, that the driver was under the influence of alcohol or a controlled substance. And number three, that they were under the influence of alcohol or a controlled substance to the extent that their normal faculties were impaired. Normal faculties being impaired can be established by a blood alcohol reading of a 0.08 or above if shown through chemical testing such as the CMI Intoxilyzer 8000. I'm William Moore. Thanks for listening.